One of the questions we often get asked is, do I really need a lawyer for my will, or can't I just use a will kit? My estate's pretty simple. Do I really need to pay the extra cost associated with coming to see a lawyer? And my answer to that question is always, well, you should go get that advice. It's well worth it because it can avoid complications down the road. My other flippant response sometimes is, you can technically go and rebuild the engine in your car, but wouldn't you be better off paying a mechanic to do it? Here's the three most common complications associated with doing a will yourself. The first is, we've noticed that homemade will kits or holograph wills tend to be drafted based on what you own today. One of the things we know that occurs through our experience in estate administration is that assets change and people in your life change. So after death, what often occurs is either your will contains assets that no longer exist, or the beneficiaries named in your will stand to inherit an estate, and you may not have intended that, or may not have intended that on death. Either way, your estate plan hasn't been carried out. By drafting your will through a lawyer, we contemplate contingencies and ensure your estate plan reflects what it is you want to happen and has the flexibility to adapt to changes in your assets or to changes in people in your life. One of the other concerns we see is will kits or homemade wills often contains gifts that just don't work, either from an administrative perspective or because they no longer exist. For example, there's a tendency to include a lot of specific gifts in a homemade will, which all seems fine and good until it comes time to distribute them. Leaving a number of specific gifts to minor beneficiaries can be incredibly complicated, even if they are well intended. For example, a $500 gift to a great-grandchild may have to be held in trust by somebody for up to 16 or 18 years until that child is able to inherit. That's an awful lot of administrative work for a relatively small amount of money. And of course, formalities of a will are extremely important. Wills have to be witnessed in a certain way to be valid. If you miss any of these formalities, your will could be held invalid, and if your will contained provisions which excluded certain people from inheriting your estate, you run the risk of having these people actually getting a share of your estate. Items such as the number of people witnessing your will and who witnesses your will can be very important. For example, having your spouse or a beneficiary of the estate witness your will can actually disinherit them from your estate. We urge everyone to go seek professional advice with respect to their will to ensure their estate plan can be forward. If you have any questions or if we can help you make your estate plan happen, please give the office a call.